In the big picture tonight, the Supreme Court handed down opinions in closely watched cases on the final day of their term yesterday, and now they're having ripple effects in courtrooms across the country.
The U.S. Supreme Court upheld Idaho and West Virginia state laws requiring student athletes to compete in sports corresponding with their biological sex. We have team coverage for you tonight, looking at what swayed the court's decision and how it could impact local school districts that allow students to use bathrooms and locker rooms based on gender identity, not biological sex. Nick Minock has this story now from Loudoun County.
The High Court's new decision now makes it harder for Loudoun County Public Schools and other Northern Virginia school systems to legally defend their transgender locker room and bathroom policies, because the Supreme Court's decision made it clear that under Title IX, sex is based on biological sex, not gender identity. Right now, students can use bathrooms and locker rooms of the opposite sex based on their chosen gender identity in public schools in Loudoun, Prince William, Alexandria, Fairfax, and Arlington. Attorney and Loudoun County resident Ian Pryor is with the conservative group America First Legal, which filed an amicus brief in support of the court's eventual decision. He has represented students in previous locker room cases and says the SCOTUS decision makes it easier for a student to successfully sue if that student has to share a bathroom and locker room with a student of the opposite sex.
I would predict that a student who comes and sues Loudoun County Public Schools because she has to share a locker room with a biological male and then is told to go somewhere else, that she's going to be successful in that lawsuit following the Supreme Court's decision. It guts Grimm. It effectively overrules Grimm.
Grimm versus Gloucester County School Board is the lower court case that 5 Northern Virginia school districts use to defend their transgender locker room policies. For instance, Loudoun County Superintendent Aaron Spence said this in a recent congressional hearing.
Do you think it's appropriate for boys to sleep in the same room as girls on field trips?
It's appropriate and lawful for transgender students to be able to be treated as their consistently identified gender.
Alexandria and Fairfax school divisions tell 7 News they're reviewing SCOTUS's ruling to see if changes are required. But Arlington Public Schools already says they don't plan to make any changes, saying the court's decision held that states may ban transgender girls from participating in girls' sports. APS says the decision involved the context of sports rather than restroom and locker room access. APS adds the ruling did not overturn Grimm. Therefore, APS says it will continue to comply with Grimm. Yeah, when it comes to the locker room and bathroom policies of Fairfax County Public Schools and Loudoun County Public Schools, do you think they will be forced to change them, or do you think they'll do them willingly?
Well, if I had $5 to bet, I would say that they're going to be forced to change them through further litigation.
Pryor says the SCOTUS ruling will also make it easier for the U.S. Department of Education to enforce Title IX. Last year, the U.S. Department of Education found the 5 school systems, including the one here in Loudoun County, are violating Title IX with their locker room and bathroom policies. But the school systems defend their policies and have kept them in place. Reporting in Middleburg, Nick Minock, 7 News.